Hello everyone. Today, together with me are Ilya, Ashley, Yuze, and Xing We will be discussing the legal protection against sexual offences among Malaysian university students. Sexual offences can happen to anyone at any location, including educational institutions like schools and universities. This unwanted sexual behavior disrupts the victim's ability to study or participate comfortably in university life. This includes behavior like sexual assault, sexual harassment, rape, etc. According to a research done by a group of students from Uni SZA in 2013 on sexual offences, their responses towards them shows their lack of knowledge and misunderstanding about it. It was also concluded that a lot of undergraduates do not realize that they are experiencing sexual offences as they do not know the actual concept and the law behind it. The issue of sexual offences committed against university students is long-standing, yet it continues to receive limited attention. Hence, it is essential that we define what is sexual offences and what constitutes it and what are the legal protections under the Penal Code. In our discussion today, we'll break down the relevant sections of the Penal Code that define and criminalize behaviors like rape, incest, carnal intercourse, and verbal or non-verbal sexual harassment. We aim to address the common misconceptions and to clarify rights and protections available to the university students in these situations. We hope they can recognize and understand what means of the legal protections and be more confident to seek help if they experience or witness such behaviors on campus. By clearing up misconceptions and reviewing the rights and protections available, we hope you'll feel more informed and empowered to seek help or support others who might need it.
Rape is one of the most serious sexual offences, causing extreme trauma to victims and often leading to significant disruption within families, particularly when the perpetrator is a family member. It is essential for students to understand the legal definition of rape, who can be a victim, and the evidence required to secure a conviction in court. According to Section 375A and B of the Penal Code, rape occurs when a man engages in sexual intercourse with a woman without her consent or against her will. Despite the alarming trend, male rape cases has yet to be addressed as rape as of now. Currently, the law only protects men against other sexual offences, which my other members will cover later on. While many associate rape with scenarios where the victim explicitly says no or physically resists, it is important to understand that consent is not always verbal or physical. As established in Crown against Alduk Boja, there is a difference between consent and submission. Every consent involves submission, but not every submission amounts to consent. Furthermore, Section 375C to F of the Penal Code address circumstances where consent is invalidated. These provisions underline the critical role of consent in establishing rape charges under Malaysian law, and therefore the absence of body injuries or any other physical violence does not affect the judgment of the court, even if the girl is a willing partner or enemy to the accused. However, to prove a rape cases in Malaysia, the prosecution also relies on various forms of evidence, and the strongest being the medical report, which often includes signs of penetration, such as torn hymen. However, in cases where there is a delay in reporting the crime or conducting medical exams, it may be difficult to pinpoint the exact time of the assault. In such instances, other corroborating evidence becomes crucial. This can include consistent testimony from the victim and witness testimony, DNA evidence such as semen on the victim's clothing, and any other relevant evidence that support the victim's account of what happened. In cases where pregnancy occurs, DNA profiling of the fetus may also help link the perpetrator to the crime. Additionally, Section 375 of the Penal Code includes exception to the general rule of what constitutes rape. Sexual intercourse between a man and his wife within a valid marriage is generally not considered rape. However, there are specific circumstances where this exception does not apply. For instance, if a woman is living separately from her husband under a degree of judicial separation, has initiated a divorce proceeding with a decree nisi, which means not yet absolute, or has obtained a court injunction prohibiting her husband from sexual intercourse, she is no longer regarded as his wife for the purposes of this exception. Similarly, during the iddah period, for Muslim women, this exception also does not apply. This distinction is particularly relevant for university students, many of whom are of legal age to marry and should be aware of their rights and protections under the law. Beyond individual rape cases, Section 376 sub 2 of Penal Code also addresses specific circumstances involving sexual crimes, which prescribes harsher penalties for aggravated rape. This includes offences involving victims under 12 years old, victims under 16 who become pregnant, gang rape, or rape committed alongside other crimes such as robbery. Additionally, crimes involving threats, weapons, fear of death, or abuse of authority or trust are categorized as aggravated rape.
Students have to know that incest and rape are two distinct offences. Incest requires an additional element to be proven, wherein the relationship between the perpetrator and the victim needs to be determined. Under Section 376A of the Penal Code, incest can be committed by either a male or female. It protects men in the offence of incest, which is not shown in the offence of rape. Whoever who consented to incest will also be guilty of the offence of incest. It also requires that the relationship between parties is at a relationship that is not permitted at law, religion, custom, or marriage. This includes sexual intercourse committed by a father to daughter. However, Penal Code also provides the protection to the victim if the sexual intercourse is not being consented to. It stands as a valid defense. If consent was given by a person under the age of 16, the consent is given is invalid as the person giving the said consent is deemed to not be able to give the consent. The Penal Code also protects that if there is no knowledge that their relationship is prohibited when they committed the sexual intercourse, it is also a valid defense. As mentioned earlier, rape only constitutes of a penetration of a penis into a vagina. In our Penal Code, it also prohibits the act of carnal intercourse, which means the penetration of penis either in the anus or mouth. In the Penal Code, it was also explained that as long as there is penetration, it suffices to constitute the sexual connection needed for this offense. It does not matter how deep the penetration is, regardless whether the depth injures the hymen, as long as the penetration is proven. The existence of semen, however, will definitely prove the existence of penetration, but it is not a necessary element to be proven. Under the Penal Code, the element of consent for carnal intercourse is not expressly mentioned. However, the Penal Code did mention that as long as carnal intercourse was committed either against the will or without the consent or putting fear of death or hurt to another person, it is an offense and is punishable. Thus, it is possible that the offense of carnal intercourse to occur even between a husband and wife, so long as the act was done against the will of the victim or putting the victim in fear of death or hurt. Thus, students do have to know that the Penal Code protects anyone that is a victim of carnal intercourse, regardless of how prominent or prestigious the perpetrator is. Under incest and carnal intercourse, it both requires a penetration of a penis. If an object or other body part besides the penis is used to enter the vagina or anus of the victim, it will not fall under the offense of rape nor carnal intercourse. However, it will fall under Section 377(c)(a), sexual connection by object. Students have to take note that this introduction of object or body parts can only be either into the vagina or anus. It does not include the introduction of object into the mouth. Besides, it needs to be proved that this sexual connection was done without the other's consent. It was held in courts that sexual connection by object is committed as the perpetrator introduced his finger into the vagina of the victim without consent. This is a provision that students can rely on if there is an introduction of either an object or any body part into their vagina or anus. The Penal Code codifies it differently as the elements needed to be proven for each is different.
What was I to do? Go to the police and then what? There are no laws protecting me. We are gradually shifting the conversation towards me a victim of sexual violence, an area often overlooked due to common stereotypes about gender and rape. In Malaysia, there is a prevailing misconception that the law does not protect mere rape victims, or that rape cannot be committed by a woman against a man or a man against another man. It is important to clarify, however, that while Malaysia's legal framework under Section 377 of the Penal Code criminalized sodomy, defined as carnal intercourse against the order of nature, but the law does not explicitly classify this act as a rape. Instead, the provision criminalizes voluntary carnal intercourse between individuals of the same sex or with animals, without necessarily recognizing it as a rape in the traditional sense. It's also important to note that Section 377A and 377B prohibits carnal intercourse against the order of nature, with a penalty of up to 20 years of imprisonment and whipping. Section 377B applies regardless of consent, meaning that the law criminalizes these acts even if they are consensual, while 377C especially target acts of sodomy committed without the consent of against the will of either person shall be punished with imprisonment of for a term not less than 5 years. This gap in the law often leaves male victims of sexual violence without the full legal recourse afforded to female victims of rape under more commonly understood definition. As awareness of male sexual assault rises, it is essential to recognize and address this legal nuisance to ensure that all victims, regardless of gender, are affordable the protections and justice they deserve. Other than this, Section 377D offers crucial protection for students against acts of gross indecency, whether those acts occurs in public or private spaces. One concerning cases, students are coerced into performing indecent acts to gain approval from seniors. While some may think these actions are harmless, Section 377D explicitly criminalizes such coercion, making it a punishable offense. Even if a student agrees to participate, the pressure to confirm and the power imbalance involved make the consent invalid under the law. If a senior acts, force, or manipulates a junior into performing an indecent act, as abets the commission of, that is considered to be fall under the offences of gross indecency under Section 377D, which can result in a prison sentence of up to 2 years. The law does not discriminate. It applies to any act of gross indecency between males, females, or both. Another scenario where Section 7D plays a vital role is in cases of public indecency, such as masturbation in public spaces. There have been reports of such acts being committed in public with offenders arrested under this section. For example, imagine a student being coerced into performing such an act in a public area on campus, perhaps as part of a dare or an attempt to impress others. In this case, section would cover both the act itself and the coercive circumstances that led to it. The law is designed to protect students from being manipulated into engaging in sexual behavior that is both grossly indecent and publicly humiliating. Whether the act occurs on campus or elsewhere, Section 377D ensures students are protected from exploitation. Ultimately, this section could potentially empower students to say no and provide them with the legal backing to stand up against sexual abuse. If you ever find yourself in such a situation, remember that you have the right to refuse and the law will protect you.
University students should also be aware of sections 354 and 509 of the Malaysian Penal Code, which offer essential protection against both physical and verbal forms of sexual harassment, safeguarding personal dignity and safety. Section 354 criminalizes any act of assault or use of force intended to outrage a person's modesty. This protection is broad and covers instances where someone may cross physical boundaries, including unwanted touching, grabbing, or any act intended to intimidate or humiliate. Significantly, the provision is gender neutral, protecting all individuals from harassment, regardless of gender, thus creating a more inclusive layer of protection on campus. In practical terms, students can feel assured that if someone's action, whether in academic or social settings, are physically invasive or intended to compromise their personal space and dignity, they have legal recourse under Section 354. Penalties for offenders are severe, including up to 10 years imprisonment, fines, or caning. This strict enforcement serves as a deterrent and it reinforces a culture of respect within university settings. While Section 354 addresses physical harassment, Section 509 extends to verbal and non-verbal form of harassment intended to outrage the modesty of a person. Verbal harassment involves hurtful or offensive language directed at someone due to their gender, such as using terms like stud, babe, chick, or sexy, which may carry inappropriate implication. Physical harassment included unwanted contact, such as touching, grabbing, or pinching in a sexual manner, and can even amount to sexual assault, a criminal offense. Non-verbal harassment can involve staring or making suggestive gestures. Unlike some laws that focus specifically on women, Malaysia's Section 509 refers to person, making it applicable to all genders. This gender neutrality further aligns with the intention to make all students feel safe from harassment, whether in the form of inappropriate language, suggestive remarks, or intrusive gestures. In terms of practical steps, students who encounter any behavior covered under Section 509 should document the incident by recording details such as date, time, and place, along with any evidence or witnesses. Universities often have support services, including counseling and formal reporting channels. These resources provide a structured process for addressing complaints and offer emotional support to students affected by harassment. For severe case, students also have the option to report directly to the police. In cases involving modesty, Malaysian courts interpret modesty as a concept closely tied to personal dignity and comfort, though the term itself is not explicitly defined. The case of Muhammad Fairoz bin Ahmad against public prosecutor draws on this idea, closely aligning it with the interpretation under Indian Penal Code. For example, in Mr. Surupan Diol Bajaj and Kanwar Pal Singh Gill, India's Section 509 was applied to protect modesty, though it is specific to women. Malaysia's gender-neutral language makes it broader, recognizing that modesty and personal boundaries are essential rights for all individuals. In conclusion, university students can rely on this section of the Penal Code to help protect themselves from harassment and to contribute to a respectful and secure campus culture. Reporting incidents, whether they involve verbal, non-verbal, or physical harassment, is crucial for reinforcing a campus atmosphere that does not tolerate misconduct and values the dignity and personal boundaries of all. Most universities also offer counseling and support services to assist students who have experienced harassment. These resources can help individuals navigate the reporting process and manage any emotional challenges resulting from the incident. By engaging in this support system, students can gain guidance and reassurance, helping to foster a safer and more supportive campus community for everyone. And that's all from us. Thank you. This is all of our bibliography.